so we are good to go here. We're live streaming on YouTube. It is September 28th, 2021. Judge Knight's here presiding on the first appearance calendar. Looks like we may have lost Deputy Oglesby. Who's the deputy on the male side?
Yes, Your Honor, that's correct. That's going to be Deputy Oglesby.
All right, who are you, Deputy?
Deputy Riccanio.
Riccanio, what's going on with you this morning? Good morning to you.
I'm doing well. How about yourself?
Doing pretty good. It looks like we lost him. All right, so we'll be on standby. Counsel, good morning to you, sir. Sean Goldstein.
Good morning, Your Honor.
Good morning to you. Who's your client this morning?
Judge, I'm here on behalf of Melvin Leon Sloan.
Okay, Mr. Sloan. Mr. Goldstein, I don't think we met before.
No,
nice
sir.
to see you here.
Thank you, sir.
Do you wish to waive my former readings and just go ahead and first appear your client?
Yes, sir.
All right. And Deputy Riccanio, can you bring him forward, Mr. Sloan, please? We're just going to go ahead and do him informally without all of the rights and everything. And then we may go ahead and do the males while we wait for Deputy Oglesby to come back. All right, Mr. Sloan, good morning to you, sir. Are you Melvin Leon Sloan?
Yes, sir.
All right, Mr. Sloan, you're charged with one count of theft by taking. It's the felony kind. I have a special condition, which means you cannot go to this location. It is 2750 South Point Drive in Forest Park. You cannot return to that location at this time. And also, sir, you have a first appearance that at this time is scheduled for November 15th at 8:30. If you bond out, that is waived, and you can speak with Mr. Goldstein further on that. I do have a bond amount, but I'll hear from your attorney here to see if I will consider a different number.
Your Honor, Mr. Sloan has been in Georgia for about 23 years, Judge. He resides in Snellville with his fiance. Judge, they have a child together who's 4 years old. There are 3 other children that live in the house, all daughters. 10, 16, and 19 years of age. Judge, he's lived here for 23 years. He works at Best Buy delivering appliances, Your Honor. And Judge, I don't think he has any failures to appear. Judge, I think he's a very good candidate for bond. And I would just ask that, he is a working man, Your Honor. He works very hard, 40, 50 hours a week. And I would ask that the court just impose the most reasonable bond that the court would allow.
Yes, sir. I did review it and did have a bond in mind here, but based on Mr. Goldstein, based on your statements here on Mr. Sloan, I'll go ahead and reduce it. Mr. Sloan, your bond amount will be $10,000. Understanding the nature of the offense and the amount, the alleged amount there, I believe that's more than reasonable. And you can thank
Absolutely.
your attorney for that.
Thank you, sir.
Would not have been that, just so you know. Mr. Sloan, stay in touch with your lawyer. Any questions from either?
No, sir.
All right. Thank you. You both have a good day.
Thank you, Your Honor.
And Mr. Goldstein, nice to meet you. We'll see you next time.
Pleasure's mine, Judge. Thank you, sir.
Yes, sir. All right, looks like we have, there we go. All right, Mr. Sloan, you're good to go. All right, Deputy Riccanio is back here. All right.
When we see, so we get that done. Where's your mask? They didn't have that.
All right, so it looks like we're good to go on both sides here. All right, let's try this again here. Good morning, everyone. It is September 28th, 2021. Judge Knight's presiding. First appearance calendars, Clayton County Magistrate Court. I'm here today to inform you of your charge or charges against you, your bond amount if you are entitled to bond, your next court date, which is your preliminary hearing date, and appoint an attorney to represent you if you so qualify. What's happening today is, most importantly, is that I'll tell you what your constitutional rights are. These rights remain with you. They never go away. And you need to make sure that you are listening very keenly here today. So first off, you have the presumption of innocence. The state, which is the district attorney for felonies and the solicitor general for misdemeanors, have the burden of proof, and they have to prove this charge or these charges against you beyond a reasonable doubt. You have a presumption of innocence throughout these proceedings, and that presumption does not go away. You have the right to compel the attendance of witnesses to testify on your own behalf and to present evidence. You have the right to see, hear, and cross-examine any witnesses that the state may call to testify against you. You have the right to a speedy and public trial by jury. Also, you have the right to an attorney to represent you at all stages in these proceedings. One thing on if you choose not to testify, you can represent yourself, and you can choose not to testify. If you choose not to testify, the presumption of your guilt may be raised. However, remember, you always have the presumption of innocence until the state can prove your guilt beyond a reasonable doubt. So I'll go over the application for appointment of counsel form that you completed earlier this morning with you. Want to let you know about bond. This is magistrate court. So what happens here to this morning is we are not having a trial. We're not having a discussion about the facts of your case. This is being streamed live on YouTube. That means that any prosecutor or anyone else can review this recording at a later date. So please resist the urge to tell me facts about your case, because you may incriminate yourself. You may think you're helping, but you may not be. Resist that urge. Tell all the facts of your case to your lawyer. This morning, I will go over your charges with you and tell you your bond. Some of you may not be getting a bond because of the nature of the offense, and that's not because of anything personal. It's because I can't give you a bond because it's magistrate court, and magistrate court judges can't give you bonds on certain offenses. You have to wait to see a superior court judge. Now, magistrate court judges can sit as a superior court judge by designation, but today that is not the case because we have to wait until the next court date, which is the preliminary hearing. The preliminary hearing is also known as a prelim or probable cause hearing. The probable cause is simply an articulable statement or statements that the arresting officer or detective or investigator, some law enforcement officer, they have to articulate and say, this is why I arrested you. And if it's a valid reason, then your case is bound over to state court if it's at least misdemeanors or one misdemeanor, and it's bound over to superior court if there's at least one felony. If it's the reason is invalid, then your case will be dismissed. So that's what's happening at your next court date. Your preliminary hearing for felonies will be November 15th at 8:30. For misdemeanors, it's November 16th at 8:30. If you don't have a bond, I'll give you that bond date once I speak with you. Now, if you bond out of jail, which you are entitled to do and should, if you can, then that preliminary hearing goes away and you'll just wait for notice in the mail to attend your arraignment in state court or superior court. If you don't get a bond or you're unhappy with the bond or the bond conditions, then you speak with your lawyer. Your lawyer can negotiate with the state to come to a different bond agreement, or you can wait till your preliminary hearing if you're still in custody at that time. Also, there's special conditions of bond. Special condition means you can't go somewhere or you can't contact someone. If I say don't go to 123 Main Street, you can't go. If I say don't contact Joe Smith, can't contact Joe Smith. That doesn't mean it's like that forever. It just means, of course, as I mentioned, once you speak with your lawyer can get that changed. For the gentleman you just saw, we have Mr. Sloan while we were waiting on the females to come back up. We have Mr. Sloan. So that's a special condition. I told him not to go to a location, and that's based on the nature of the offense. And it was a theft offense. So you can't go back to a place where you stole from. So that's an example of a special condition. You can't have contact with a person where there was some type of violence against that person. So that's not rules I'm making up today. That happens every day. We have first appearance 7 days a week. 365 days a year. There's court every day, holidays, weekends. And so it's not unique to you. We have to follow the law. So it's not personal. Speak with your lawyer. Your lawyer can change all of those things. As of today, that's what it would be until it's changed or until the charge or charges against you are disposed of. So keep in mind, if you violate any of the special condition of bonds, it can result in additional criminal charges. Aggravated stalking, influencing a witness, other offenses can be added to your list of charges. So keep that in mind. Also, once I call you up individually, I will let you know what your charge is, your charges, your bond amount, if you're entitled to a bond. Preliminary hearing date, which again for felonies is November 15th, misdemeanors November 16th, 8:30. Appoint an attorney to represent you if you qualify. And lastly, I'll ask you if you have any questions related to those 4 things I just mentioned. Each of you raise your right hand. All right. You solemnly swear, affirm any statements or testimony you may make in this first appearance matter not pending before the court shall be the truth, the whole truth, nothing but the truth, so help you God.
Yes.
All right. Let's do it. We'll do the females first, deputies. That was happening.
Yes, sir.
All right, let's do it.
Ms. Baggs?
All right, Ms. Baggs, good morning to you.
Good morning.
All right, charge of 1 count of simple battery. That is a misdemeanor, and your bond is $3,000. There's no contact with Ariane Michaela Thornton at this time. There's a preliminary hearing, it's 16th of November, 8:30. And lastly, Ms. Beggs, I am appointing an attorney to represent you. You have any questions?
Not really.
All right. All right. Thank you, ma'am. Good luck to you.
Ms. Graham?
All right, Ms. Grant, good morning to you. You know what you're charged with?
Yeah, a little bit.
All right. You're charged with depraved child, 4 counts of that, cruelty to children, 4 counts, reckless conduct, 4 counts, 12 counts is your total. And preliminary hearing is November 16th, 8:30. And I did want to ask you, Ms. Grant, and I don't want you to tell me too much, or if you don't want to tell me, this is in consideration. I have a bond amount here, but I did want to ask you, ma'am, you were employed at this time when this was happening, or were you at work? Or where were you?
I was at work, sir.
Okay. All right, ma'am. I do have to give you a bond, and I do realize it's 12 counts, so it's 1,000 on each of those. It's 12,000 is your total, and that's as low as it can go. I understand the situation, ma'am, but unfortunately, I have to give you a bond. You understand what's happening here? All right, and I will appoint an attorney to represent you. Do you have any questions?
No.
All right, thank you. Good luck to you.
Ms. Johnson?
Yes, ma'am, Ms. Johnson.
Yes.
Good morning to you here. You're charged with one count of battery or simple battery. No contact with DeAndre Wilkins at this time. Your bond is $3,000, and I am appointing an attorney to represent you. Preliminary hearing is November 16th at 8:30. Do you have any questions, Ms. Johnson?
No.
All right, thank you. All right, Ms. Jones, good morning to you, ma'am.
Good morning.
All right, charge of one count of reckless conduct. No contact at this time with Marco Slaughter. Do you all live together?
No.
All right, your bond is $2,000. 16th of November, 8:30 is your preliminary hearing. Ms. Jones, I am appointing an attorney to represent you. Do you have any questions?
No.
All right, thank you.
Justice.
All right, Ms. Justice, good morning to you. All right, one count of loitering or prowling. Special condition, you can't go back to 771 Conley Road. Your bond is $1,000. Preliminary hearing is November 16th at 8:30, and I am appointing an attorney to represent you. Do you have any questions, ma'am?
I don't understand why I'm in here.
Can you say that again, please?
I don't understand why I'm in here.
All right. You're in here in the Clayton County Jail because on September 27th, 2021, the warrant reads that you committed the offense of loitering or prowling when you were inside a vacant home without the owner's permission. The owner is Melanie Turner.
Melanie,
Yes, ma'am.
I thought the owner was Randy Smith.
Well, that will be for a different day and time, ma'am. The charge is loitering or prowling, and you did not get permission from the owner, and that is what
Bill Cabrera is the one that owns it now.
All right, I don't know that, ma'am. You speak to your lawyer, and your lawyer can deal with that.
So I've already got a bond.
Yes, ma'am. 1,000. All right. All right, deputy. Thank you. Thank you.
How, if I don't have anyone to bond me out? Actually, I've already gotten bonded out.
Yes, ma'am.
Why did I have to come to, why did I
That
have
will
to come to
conclude your
hearing?
first appearance this morning, ma'am. Stay in touch with your lawyer. Deputy.
You're done. You're done with you, ma'am. Ms. Roberts?
What was your name?
No.
All right, Ms. Roberts. Good morning to you.
Good morning.
All right, one count of violation of the Georgia Controlled Substances Act, possession with intent to distribute marijuana. There wasn't an amount listed on the warrant, so I'm going to give you a bond of $7,000, which is lower than it normally would be, ma'am. But the warrant was vague on the amount. There was scale and baggies, but not an amount of marijuana. Also, loitering or prowling is 1,000. Public indecency is 2,000. It's a 10,000 total bond. Preliminary hearing scheduled for the 15th of November, 8:30. And I am appointing an attorney to represent you. Ms. Roberts, you have any questions?
No, sir.
All right, thank you.
Ms. Arano? That is gonna be the fugitive, Your Honor.
Fugitive. Yes, sir.
Good morning, Your Honor.
Good morning to you. Miss Serrano?
Yes.
All right. All the rights that I outlined, they all apply to you, ma'am, except you're here for a slightly different situation here, ma'am. You're here for the beginnings of a extradition hearing. I must inform you of that process. What's happening is you are here and a hearing will be conducted under the OCGA Title 17, Chapter 13. The OCGA is the official code of Georgia, annotated, ma'am, and that is our law here. You have, or I have, a warrant here that pertains to you. The warrant reads that Gloria Serrano did enter and remain in the state of Georgia and is wanted by the New York City Police Department for dangerous drugs. That offense is a felony, and they will extradite. That's what the warrant reads, ma'am. I normally can give a bond. However, because you're a fugitive, there will be no bond today. You have options. You can contest or fight this extradition. You can remain in custody for 30 days. A warrant will be prepared under the seal of Governor Brian Kemp, Georgia's governor. And then you can contest 4 things. 1, whether the extradition documents, that's the warrant, and any other documents related to this offense that we have here in Georgia, whether those documents are in order or correct on its face. Secondly, whether you were charged with a crime that is in fact a crime. Now, for example, marijuana is legal in many places, right? Certain amounts. So this offense of dangerous drugs may no longer be a crime. So you can contest that. Thirdly, whether you are in fact Gloria Serrano, you can contest whether you are in fact the person named in the extradition request. And lastly, you can contest whether you're in fact a fugitive. Maybe you have permission to travel. Maybe something else is happening. So those are the 4 things, and the 4 things only that you can contest. You can remain in custody in the Clayton County Jail for up to 90 days for that process to be completed. However, you can waive extradition, and the state of New York will have 10 days, and I believe that's generally business days, to come to get you or make arrangements to take you back. You can do so.
Yeah.
And if you, oftentimes they come within that time period, but there can be a request for an extension, and that request is generally granted. So you can remain in custody longer than the 10 days, but that's the general time period. So at this time, Miss Serrano, do you have any questions? Also, I must ask you if you wish to waive extradition or contest, fight it.
Yes, to waive, right?
Yes, ma'am. All right. I've sent over some extradition forms there that I've already signed. And Deputy, if you have those, you can have her sign. I believe your signature block may have the 28th. So when you sign, the 29th. So when you sign, if you can change that to the 28th of September on each of those forms and sign off, ma'am. Do you have any questions?
No, I really do.
No questions. All right.
So, yes, I do, Your Honor.
Yes, ma'am.
So I was in, I went to do a criminal background check because I used to live here in Georgia. And I went to Cumberland and Tucker for a criminal background check for a new job. They arrested me there. They had me there for a couple of hours, and then New York called them. They uplifted my warrant. So this is the same thing right now. I haven't got in trouble at all, Your Honor.
Yes, ma'am. But the only problem is because we're not in New York, I can't do anything about it. Right. And the warrant that I have shows that they will extradite you. So you have to deal with it there. So the only thing that we could deal with in Georgia is whether you wanted to fight extradition or not, and you're not fighting it. So within 10 days, you'll be back there, and you can deal with it then once and for all, and hopefully move on with your life after that's resolved there in New York, ma'am.
Thank you so much, Your Honor.
All right, you're welcome. What part of New York are you from?
Manhattan.
All right, I grew up in Brooklyn, Flatbush.
Okay.
Yeah, I went to high school in Park Slope in Brooklyn.
Park Slope, yeah.
And I went to college in John Jay on 59th Street, Columbus Circle.
I have my custodian maintenance certificate from John Jay College.
Yes, ma'am. So you know that's the best school for criminal justice
Yes.
in the world.
Yes.
All right. Well, good luck to you, ma'am. I understand the situation, but there's not much I can do, okay? I'm sure it'll work out for you if it's like the way you said it is, okay?
Okay, thank you so much.
Yes, ma'am, you're welcome.
Be blessed.
You too.
Okay.
All right, Your Honor, that's gonna conclude everybody on the female side.
Yes, sir. Thank you very much. See you next time, Deputy Kenya.
Sir, have a good
All
day.
right, you too. All right, Deputy Oglesby, let's do it. All right, gentlemen. Let's let them know it's muted. It's muted.
Okay, go ahead.
Unmute. There we go. Perfect. Yes, sir.
George Embers.
What's your name?
George Embers.
Okay, yeah, Mr. Embers. Good morning to you, sir.
Good morning.
All right. You're charged with one count of aggravated assault by strangulation. It's a felony. It's a serious one, sir. Battery, family violence, and simple battery, family violence. On the aggravated assault, the bond is $10,000. Battery is $5,000, and the simple battery is $3,000. It's $18,000 is your total, sir. You can't have contact with Shannon Penley or Pennyman. I'm sorry. You cannot return to the 157 Little Joe Court, Riverdale address at this time. If you must return, Mr. Embers, you must have law enforcement go with you. You must contact the Clayton County Sheriff or police. Local law enforcement must go with you to that location to get any belongings. You must do so within 10 days of your release. Sir, you understand what you're charged with, special conditions of bond?
Yes, sir.
All right. Preliminary hearing scheduled for 15th of November. This is your application here. I will appoint an attorney to represent you. Do you have any questions?
Yes, sir. If I'm able to get one, will I be able to do so?
Yes, sir. If you can bond out, you can do so. Yes, sir. If there's no holds on you, then you're good to go.
Okay.
Yes, sir. All right. Thank you.
Thank you. Thank you.
All right.
Come on, sir. My first name is Isaiah. My last name is Eden.
Yes, sir, Mr. Eden. Good morning to you. Two counts here. Your first count is battery, it's misdemeanors. 5,000 is the bond. Second count is cruelty to children. First degree is 2,500. 7,500 is your total. Dexter Monk. Who is that, sir?
That's my 14-year-old brother.
Is that your brother?
Yes, he's my younger brother. I have custody of him.
All right, you have custody of him. Does anyone else live there?
No, it's just me and him. I was raising him myself.
All right, I'm gonna reduce your bond, sir. All right, on the battery, it's gonna be 2,000. On the cruelty to children, it's 1,500. So it's 3,500 now instead of 7,500. Okay, it's the best I can do at this time. All right, still have to give you some type of bond based on the nature of the offense, but I do understand the situation, sir, and that's why I asked you who that was there and those follow-up questions. Please speak with your lawyer, and I'm not putting don't go to that location provision on there.
Okay.
But if as best as you can, there's no violent or harassing contact with your brother.
Absolutely. But I do have one question.
Hang on for me, sir.
Sure.
I'm noting this on the order here. All right. What's your question?
Well, unfortunately, he's in foster care. And after I buy myself up, I would like for him to come home. I don't want him to be in foster care. So is there anything restricting me from having contact with my brother? I'm the only person he has. That's why he's in foster care.
I noted on there, no violent or harassing contact.
Okay.
All right. Have to put a condition on there. And that's what it would be. No violent or harassing contact. Not no contact at all, but no violent or harassing contact. That means you can have contact just in the regular way.
Mm-hmm.
And good luck to you with getting your brother back, sir. And I understand the process, and I know that you can do it. It's the 16th of November at 8:30. Tell your lawyer all the things you just told me, and I've appointed one to represent you, sir. Good luck to you, Mr. Eden.
Thank you.
You're welcome.
So get the first name and your last name. Jonathan Forrester.
All right. Yes, sir. Mr. Forrester, good morning to you.
You want to
All right, let's see here. One count of criminal trespass is a misdemeanor. 2,500 is the bond amount. It's no contact with Leanne Nicole Nevins at this time. And the 16th of November, 8:30 is your preliminary hearing. And Mr. Forrester, what is your monthly income?
I don't know, probably about 800 a month at the most, if that.
All right. I am appointing an attorney to represent you, sir. You have any questions about anything I just said?
No, sir.
All right. Thank you, sir. Good luck to you.
Thank you doing, sir. First name, last name.
Andre Hubert.
All right. One moment here. All right. Went slightly out of order there, Deputy. Just need to find his paperwork. You said Hubert? All right, I see it now. Hubert. All right, Mr. Hubert, you charge a one count of, well, no, I'm sorry, I apologize. Was that your wife earlier?
No, this is my children's mother.
Children's mother?
Yeah.
All right. You know what you're charged with, sir?
I do.
All right. So I understand the situation, sir, and it's the same bond. It's 12,000 is the total. It's 1,000 on each of the offenses. All right. That's as low as it can go. I looked at it, I reviewed it, and I wanted to go lower, but my hands were tied, sir. It's a tough situation. And just know that, you know, I'm just as considerate and understanding as anyone else of the situation. All right. So I'm not taking it lightly, nor am I not, you know, ignoring the severity. So I understand what's happening here, sir. And I wish you the best with the children and getting them back on track. And it's 12,000. It's the 16th of November at 8:30, and I am appointing an attorney to represent you, sir. You have any questions?
No, sir.
All right. Good luck to you.
First name, last name.
Kwame Hamilton.
All right. Yes, sir. Good morning to you. What's your last name?
Hamilton.
Hamilton.
Yes, sir.
All right, Mr. Hamilton. Sir, you're charged with one count of loitering or prowling. Your bond is 1,000. Carrying a concealed weapon, it is 5,000, and driving with license restrictions, that's 500. So 6,500 is your total. Preliminary hearing scheduled for the 15th of November. That's at 8:30. And lastly here, Mr. Hamilton, I am appointing an attorney to represent you. Do you have any questions, sir?
No, sir.
All right, thank you. Good luck to you.
Jones? Yeah, Jones. First, last name.
Tommy Jones Jr.
Yes, sir. Mr. Jones. One moment here. All right. Charged with aggravated assault felony. Serious one. Shanika Jones, no contact with her. 10,000 bond on that offense. There is battery misdemeanors, 5,000. And then there is one count of criminal trespass misdemeanors, 2,500. Your total bond, sir, is 17,500. Preliminary hearing is scheduled for the 15th of November at 8:30. Mr. Jones, I am appointing an attorney to represent you. You have any questions, sir?
Yes, sir. I wanted to know what's the battery for?
Yes, sir. All right, your warrant reads. September 27, 2021, did choke the victim, wife, Shanika Jones, date of birth, by placing, looks like 1097, by placing his hands around her neck, resulting the victim not being able to breathe. The said offender then dragged the victim on the ground, causing abrasions to her legs. The victim also has abrasions to the left side of her neck from being choked. The said offender and victim are married and have a child together, making the incident family violence. The incident occurred in Clayton County, Georgia. The said offender took and kept away the victim's car, keys, and cell phone from her until officers arrived on the scene. The said offender admitted to the charges.
I didn't actually tell them that I actually dragged her. I never did drag her, sir. I did say that I did. I didn't choke her, but I did say that I put my hand around her neck. Yes, I did say that I did that, but I never dragged her at any point of any altercation that we ever had. I never dragged her at all.
All right, sir. That's a conversation for you and your lawyer. At this time, that's the bond. Those are the amounts. Those are the special conditions. All right.
How much again?
16,500.
Can I be able to write that down right quick? In the
Yes,
other
sir.
charge, in the last charge of what again?
So it's aggravated assault, battery, and criminal trespass.
And the criminal trespassing came from me being on that property.
The criminal trespass came from you taking the keys and cell phone.
Can you please explain to me how is that criminal trespassing? That's also my property.
Well, that's the keys and cell phone.
No,
Her keys and cell phone.
the car we were sharing, but that's just enough. Like in marriage, like we were sharing that. Her phone, yes, that's not my property. That is her property. Yes, she.
Well, there you have it, sir. You're answering your own question. It's not your property.
All right.
All right. Those are the charges, sir. Have a further conversation with your lawyer. A lawyer can spend all day telling you what the law says, sir. That will conclude your first appearance this morning.
Thank you.
Yes, sir.
Most
First name, last name.
Aaron Oliver, how you doing, Mr. Knight?
Yes, sir. Good morning. I'm good here. How you doing this morning, Mr. Oliver?
I'm doing too good.
I understand the situation, sir, but let's see if I can let you know what's happening. It is one count of robbery, felony. 10,000 is your bond. One count of theft by taking, 2,000. One count of kidnapping is 10,000. One count of simple assault is 2,000. 24,000 is your total. No contact with Mandy Lee. Can't return to 990 Highway 138 in Jonesboro. If you must return, you must make an appointment with law enforcement to do so within 10 days of your release. Also, Mr. Oliver, preliminary hearing is the 15th of November, 8:30, and I am appointing an attorney to represent you. You have any questions?
I don't even know the address you just said, and so I'm just like, none of this really even happened. My question is like, they just serious charges, you know. I was wondering like how somebody
can you go and put charges like that on somebody, just say they did that and there's no probable cause or no proof or nothing? Because none of this happened. There was no robbery, there was no kidnapping, there was none of this happened. I don't even know the address you just said. I've never heard of it before. None of that ever happened. And this girl should be able to contact me, right? She took these charges out of me, right? She's been blowing my phone all yesterday, the day before, the day before, ever since she put them on me and started harassing me. And I have never did none of that, you know. I was just saying, can they take charges out on you like that? Just without no probable cause?
Well, sir, that's what I have. That's what I have. I have these charges
I understand
in front of me.
I understand you do. I'm just wondering how they do that.
Well, what happened was Officer Dalton Owens swore this warrant out in front of a magistrate judge back on the 24th, and that judge signed off on it. And then you were arrested based on that warrant that was sworn out in front of another judge. So that officer must have gathered information to bring to that judge, and that judge thought it was valid probable cause at the time. So it's a state warrant. It's not a warrantless arrest.
No, what is that? What does that mean?
Well, that means that exactly what I explained. The officer went in front of another judge, swore out the warrant, and that judge found there was probable cause at the time. So certainly you can speak with your lawyer, or, you know, you should speak with your lawyer.
Oh, well,
and that lawyer, if it's bogus charges, as you're saying, Mr. Oliver, can go ahead and file the appropriate motions and be able to resolve this for you rather quickly.
Oh, so preliminary. You said preliminary 15th, man.
Yes, sir. November 15th. If you bond out before that, then
Oh,
of
no,
course.
I ain't gonna worry about that. I can't.
All right, sir. Well, good luck to you, Mr. Oliver. I hope it all works out for you. Thank you.
Morning, Mr. Knight. My name is Mark Pidian.
Pidian, good morning to you, sir. One moment here. All right, you have one count of burglary. 7,000 is your bond. Cruelty to children in the third degree is 2,000. Battery, simple battery, is 2,000, and regular battery is 5,000. Your total there, sir, is 16,000. There's no contact with Derica Russell. You can't return to the 6992 Raleigh Court, Apartment B, Jonesboro address. Preliminary hearing is scheduled for the 15th of November at 8:30. And let me back up here. You can return to that address, but if you do so, you must go with law enforcement, and you must do so within 10 days of your release. And lastly, Mr. Pidian, I am appointing an attorney to represent you. You have any questions, sir?
No, sir.
All right. Thank you. Good luck to you.
Thank you. First name, last name. My name is Cedric Sledge.
All right, Mr. Sledge. Good morning to you here, sir. You are charged with one count of battery. 5,000 is your bond. One count of criminal trespass is 2,500. No contact with Courtney Randall at this time. Preliminary hearing. 16th of November, 8:30. And Mr. Sledge, you may not qualify for court-appointed counsel based on your income, but I'm going to appoint one anyway and let them tell you otherwise. All right. You have any questions, sir? All right. Thank you. Good luck to you.
One question. How much was the second count bond?
2,500.
And the first one was
5,000.
Okay.
Yes, sir.
All right, thank you.
Yes, sir. Thank you.
That was the last one, Your Honor.
All right. So Rivera bonded out. And what happened to Jaquan Hampton?
Let me check with Stephanie.
Jaquan Hampton bonded out?
Did Jaquan Hampton bond out? It's going empty. You find out? We're checking right now, Judge.
All right, we'll get, well,
You should have been seen already.
Huh?
You should have been seen.
Yeah, he's already, yeah.
Hold on, wait, hands together, he going to.
Yeah, he funded out, Your Honor.
he bonded out. Okay,
Yeah.
all right.
That
I
was it.
appreciate it, Deputy Oglesby. Appreciate y'all. Thank you for starting a little bit early, and we'll see you next time.
Yes, sir. Thank you, Judge.
Thank you.